I'm not a violent person, and she would attest to that. It's just that I feel like free speech is free speech. If Trump could say what he want, why can't I say what I want? This is bull. Them are not serious charges of violation because they couldn't go. When I was laying on the ground, they could have went in my sneakers. What do you mean? They could have went in my sneakers when I was laying on the floor. It's not about that. You know that. I wasn't kicking. They had ample opportunity to go in my sneakers. I sat in there for damn near 45 minutes waiting, being checked by medical and all of that. That's two. And then two, alcohol, that's not even nobody gets violated on one alcohol consumption ticket. Nobody gets violated on that when you're outside. So why is that violation now? Why is that a violation now?
Your preliminary hearing.
That's bull. You're doing that for Miss Harris. All y'all work together. Y'all don't do nothing for us. Y'all don't do nothing for our people. All y'all do is want to keep us in jail because y'all some bunch of house. That's what y'all are. Frankly, that's all y'all.
Okay, everybody, and you know what time it is. It is wacky Connecticut man baby parole revocation time. And those of you familiar with this channel, you might recognize this man. I mean, surely if you've seen him, it'd be impossible to forget. We covered his first hearing back in February. And the reason that we're bringing him back today is because he's back. He's made a second appearance. So what we're going to do is we're going to watch part one. It's a good refresher. And then we're going to go into part two. We're one of the few YouTube channels that actually does this for parole hearings. We keep track of the inmates as they go through the system, and that's what we're going to do here today. Now, if you've already seen part one, I'll leave a timestamp for two in the description. But for now, buckle up, get your water, because we're jumping in. But you see, this isn't the first time that this man has chosen to represent himself. As a matter of fact, he was convicted of a bank robbery when he also chose to represent himself in front of a jury. And one of the lines that he said to the jury, it's quite comical, I think. He said, "Well, jurors, what do you feel about bank robbers? Do you support them?" They all said no. And his next question was, "Well, what about attempted bank robberies?" As if that was going to be a mic drop. Now, of course, the jury found him guilty. And as the famous Abraham Lincoln quote, what is it? The man who represents himself has a fool for a client. I don't think it could be any more true in this parole revocation hearing. Now, that bank robbery, that was just one of the crimes that he has committed. He's got a whole lot on his record. Thank you, Holly, for pulling this up. But he's got criminal trespassing. He has, I mean, it's not his first trip at the rodeo. And just you got a taste of how this hearing ends up. But let's go through the process. And I'll tell you, by the way, that this is not going to be the last that we see him. This is just a preliminary hearing. So we're going to see him again. Make sure to check the description. It's possible there is a return of, so make sure to check the link. If it's not there yet, it'll be coming soon. Now with that, let's jump.
You have the right to be represented by an attorney. You may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
I would like to proceed without counsel.
Okay, thank you. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. Charge 1, obedience to the law. On January 13th, 2025, you went into the street and walked upstairs to the Sierra Center halfway house on the 4th floor. You were previously prohibited from the Sierra Center halfway house and its premises due to intimidation and threats that you made toward a Sierra Center halfway house staff member. Due to your actions, Connecticut State Police issued a warrant for your arrest for criminal trespass, stalking third, breach of peace with a $25,000 bond. Charge 2, search. On January 17th, 2025, parole staff instructed you to sit in a chair in order to search your shoes. You refused to have a seat in the chair. You also refused to remove your shoes. This violates your special parole conditions that state I will submit to a search of my person, possessions, vehicle, residence, business, or other area under my control at any time, announced or unannounced, with or without cause, by parole or its agents to verify my compliance with the conditions of my parole. Charge 3, no consumption of alcohol. On January 17th, 2025, you rendered a urinalysis. Your specimen number P3482418 was sent to Premier Biotech Labs for alcohol testing. On January 22nd, 2025, Premier Biotech Labs confirmed that your specimen was positive for alcohol. The state has filed the following exhibits. Exhibit A, Statement of Understanding and Agreement Conditions of Parole. Exhibit B, Remand to Custody Order. Exhibit C, Notice of Parole Violation. Exhibit D, Notice of Parolee Rights. Exhibit E, Parole Violation Report. Exhibit F, Decision Information Summary. Exhibit G, Connecticut State Police Arrest Warrant. Exhibit H, Connecticut State Police Police Report. Exhibit I, the Connection Sierra Halfway House Incident Report. Exhibit J, Notice of Parole Violation. Exhibit K, Premier Biotech Labs Toxicology Report. Exhibit L, Offender Misconducts. And Exhibit M, Revocation Summaries. Mr. Riles, did you receive the Notice of Parole Violation Report, and the marked for identification purposes? It should have been like a parole package of evidence. Did you receive that?
After the continuance of this, my original preliminary hearing was scheduled on the same day as my court date. So on the 5th, I got that package. But the original notice of violation only had the one charge. I understand the urine took time to develop, so that's understandable. The other charge of refusing to let them search, I was in cuffs, I was in their custody. Technically, I was in the state police custody because he read me my rights and said.
Well, Mr. Riles, you're going to have an opportunity to testify. I just want to know if you received the evidence.
All right, yeah, after the original preliminary hearing court date, yes.
Okay, and you do have time to review it?
Yes.
Okay. And today we have no witnesses. Now it is your opportunity to respond to the parole violation charges against you. However,
right,
remember that.
Excuse me, you said we have no witnesses. I did write on my first notice that Ed was a witness because he was I got him the job where we work, and he was working with me along with another person. So I said on the first notice that they had his phone number because we both report to the same parole office, and I put him down as my witness.
Okay, one moment. So would you like him, what would be the purpose for his testimony?
To verify that what we were doing that day is distributing pamphlets, because we both work for Full Citizens Coalition, and I went to every public library in New Haven and every halfway house. I had just left. I went to Project Moore as well to drop off the pamphlets on 8th Avenue, and Walter Brooks, a halfway house I went, which I discharged from originally. And then when I went to Sierra, he was in the car along with another resident, a resident of the halfway house of Sierra, and another co-worker. So I had two co-workers in my vehicle when I went into the building that could verify that we were only there dropping off, because we do reentry now at my organization, and we have pamphlets for the clients there in case they want to call us for resume, job training, and things of that nature.
Okay.
So I wanted him to attest to that.
Okay. And you do not have his phone number?
No, that's why I put on the paper that Officer Ruiz, because she's his parole officer as well. She know his cell phone number. All I know is because of the technology now is then we don't memorize numbers no more. We just see names. So I don't recall his number.
So I'm going to just take a quick recess before I move forward, because so today you still like him as a witness today for this purposes of this hearing?
Just to attest to the job duties that we had at that day, because that was the reason I was there.
Okay, so I'm going to just take a quick recess, okay?
All right.
Back on record. So I just want to let you know that I did hear what you said today. I am taking it into consideration regarding your request for the witness. However, I'm not going to accept the witness for the following reason. Because your witness is regarding charge 1, obedience to the law, as to why you were at the halfway house, correct?
Yes.
Regarding charge 1, obedience to the law, on January 17th, 2025, a judge of the state of Connecticut Superior Court determined that there is probable cause to believe you committed the following offenses: criminal trespass first, stalking third, and breach of peace second. Therefore, I cannot revisit this finding. So regarding today, I was only going to take your testimony regarding charge 2, which is search, and charge 3, no alcohol, because a judge already established probable cause for charge 1. So testimony today will not be considered for charge 1, because probable cause was already established on January 17th by a judge.
So, this is why I didn't get an attorney, and this is why I'm doing this myself, because I have a $25,000 bond for this probable cause. There was no restraining order. There was no parole condition that I signed that said I can't be there. The last time the so-called victim, since they want to call her a victim, I'm gonna acknowledge that. The so-called victim saw me was 26 months ago when she got me arrested for threatening to inform.
Mr. Rouse, what I'm trying to say is regarding charge 1, we can't revisit this finding. So your testimony, as well as your witness you wanted to provide, the probable cause was already established. So regards to even your testimony today, it's already established. So we're not going to revisit that finding. So in terms of revocation, if we go the revocation route, absolutely, at that time it would be taken into consideration. But in terms of for the probable cause today, the preliminary hearing, testimony is not being taken into consideration. Okay. Because probable cause was already established for that one charge. But regarding charge 2, search, and regarding charge 3, no consumption of alcohol, you can absolutely testify to that today.
Okay.
Would you like to testify to those 2 charges?
Yes, ma'am.
Okay, it's your time to do so.
I had a report date of January the 16th. That day when I went to Sierra, one of the coworkers was called by one of the staff members from Sierra about my appearance there, and he suggested I don't go back because they were trying to lock me up. So this is Monday the 13th. Thursday the 16th, that was my scheduled report date. So I'm thinking that because of the situation, the misunderstanding at Sierra, that they were going to book me or remand me anyway. So that Wednesday night, I had a final good meal at a restaurant with a girl, and I had wine with my state, New York State to be exact. And that's because I thought Thursday they was going to remand me for this misunderstanding. However, come Thursday, I was only given a misconduct ticket that I signed for going to Sierra, even though I didn't understand why I was getting a misconduct, because I was not legally prohibited at that time to not be in that building for the scope of my job duties. I could see if it was a trespass or I had no business there or purpose there, that's one thing, but there was no restriction preventing me from going in that building or even around that person. However, I signed a misconduct because I didn't think, I thought I was going to get remanded because, normally they don't care. They just remand you and that's that. so that's why the alcohol was in my person, because I thought it was, I'm Muslim. I don't even drink. I just had wine that Wednesday night. But the search and seizure, that I was already in custody. As soon as I went through the metal detector, they tricked me, made it. I didn't even think I thought I was good, because the day before I just got a misconduct that seems to disappear from the evidence that they presented, because I signed that. That was my initial punishment. And the punishment was frequent report date. Like, I would have to report weekly, even though I've been doing extremely well, which I kind of argue because it didn't make sense. But then again, they do what they want. So when I went across the threshold, I was pounced on. They put me against the wall, cuffed me, went in my pockets, went in my back pockets, my side pockets, my hoodie. I had gave my leather coat to P.O. Ruiz prior to even entrance, because I didn't want to go through the metal detector holding that, so she carried that. So once they put the cuffs on, checked all of my pockets and stuff like that, the state police officer came and read me my rights. And when I heard my rights, I went crazy. I got in a panic attack, because all this is a misunderstanding and some frivolous charges. So after voicing to them that my chest was hurting, they wanted me to sit in a chair. I said it'd be better if I lay down. They wanted to go on my sneakers. I said, you can go on my sneakers. I'm not stopping you. I'm cuffed. I can't stop you. I can't stop you from doing anything you want to do to me, including bringing me to jail. So I guess they got mad and threw that in late, because the original charge was just the obedience of the law charge, which is charge 1. That's the first paperwork I got when I got in Whaley Avenue. They didn't have that issue about me not letting them search my sneakers. I can't prevent them from searching my sneakers, Miss Saunders, if I'm in their custody, cuffed up. I wasn't going to kick them. I wasn't wilding and being physically resistant. I just laid. I told them, put me down on the ground, my chest hurting. I'd rather be civically disobedient right now until the EMTs come. They came, and that was that. So originally that charge wasn't there, but I could see now that Harris and them want to throw it, whatever at the ceiling, and whatever sticks. All I want today, the reason I didn't take a lawyer, Ms. Saunders, is because I'm not trying to make a sophisticated argument to you. This is about the truth. You just told me I can't even argue charge 1, which is blowing my mind that I can't. Because I'm not copping out to those charges. I told the judge that I want a speedy trial. I'm representing myself. I want to challenge my accuser, because this is all stems from my first conviction with this woman of threatening too, which I only threatened to inform her staff that she was sleeping with clients. I was messing with a staff member in that facility. So because I was messing with a case manager, I knew who everyone was messing with. So once I stopped messing with that case manager, Ivy Collins, I still knew what's going on in the facility. Now, when she was trying to arrest me, I told her, if you jam me up for this frivolousness, I'm reporting you to your staff about who you're sleeping with. That was my threat. My threat was never physical, as you read in the exhibits from Connection, her incident report. You trying to jam me up and send me to jail? I could jam you up too, because I know stuff.
Mr. Rouse, sticking to charges 2 and 3.
All right. So, but I'm only saying this to segue into why I need to be free while I'm fighting this case. Because 1, my job, I'm the lead organizer of the state for Full Citizens Coalition, which is a Connecticut-based action group focused on undoing the unjust harm caused by felony disenfranchisement and ensuring that all citizens are respected as full citizens. That's our mission statement. I'm in charge of maybe 3 or 4 guys. We have an office in Hartford and an office in New Haven. I'm in the New Haven office on 1 Street. Now, the DNR, which I feel is not warranted because of the frivolousness of these charges, is preventing me from 1, doing my job. 2, I have a vehicle out there that's parked. I don't even know how long it could be parked or where it's at. I own it. It's registered. It's insured. I have my license. I was currently living in a parole house, which is like an apartment efficiency where you're not monitored. You basically have a key, bathroom, kitchen. That person loves me who runs the house, Roger Hines. He's holding my stuff as far as my clothing and all my property that was in the apartment. My bond is $25,000. I could have made bond the day I got arrested because that day I was picking up a check for like $1,800. Plus, my job is waiting to bond me out as we speak because I have work to do. And this is the misunderstanding, which is sad that I can't argue that with you, but I get it. The judge has supremacy over the decision makings for probable cause according to your system of adjudication. I get it. I just want, because of the nature of these charges, and it's not you. I'm pretty sure, even though I can't argue, charge one you've read. You're familiar with charge one and the background involved in charge one. I never threatened her physically in the beginning. So for her to exaggerate any type of physical threat by me,
Mr. Riles,
I'm going to get into charge one. I'm sorry, but I'm pretty sure you've deduced that it was a misunderstanding. And right now, they put a protective order on me, which I didn't even challenge. I didn't even show up to court because I don't care. There's a protective order with me and Miss for I got to stay 100 yards away from her. What else they did?
Okay, so regarding search and alcohol, regarding search, you keep going back to the number one, staying away from number one. We can't argue it. All right. So charge 2 and charge 3. If there's nothing further you have to say regarding charge 2 and 3, I could go into my findings. But if you're going to keep going back to charge 1, you can't do that because, like, again, the judge already established probable cause. But again, if we go the revocation route, you can 100% bring all of these arguments to the revocation process if we go that route. Because again, for probable cause purposes, it's already been established. Okay.
Okay. So, am I allowed to argue for why the DNR should be lifted, and I can make bond and go back to my apartment and go back to my job and fight this case, which eventually will be thrown out before I pick a jury?
Regarding charges 2 and 3, search and alcohol, and the severity of these 2 charges.
Got you. All right. Yeah. So I go through the search and seizure. They've always had authority to search my person, my car, and my apartment. They always have, and I've never given them an issue about it. Every time I go into parole for a meeting, or when I'm scheduled to meet with my parole officer, I go through the metal detector. I take everything out. It's never been an issue with that. I understand they was upset with me because I was upset about these charges, and they're just throwing whatever they can throw. The alcohol, I told you, it was the night before. I don't drink. I'm Muslim. I think I had 2 dirty urines for alcohol in the whole 3 years I've been home. And that other one was because I didn't have any marijuana and I had a nip. I don't drink. And I've taken countless urines at the Project Moore house, Roger Emerson house apartment that I stay in. We have to take urines whenever they want there, just because we're there. So I take urines with parole when I go see them every month, and I take whatever subjective urines Roger want to do with us. I follow all curfew. I've never brought in any females because we can't have company. I follow all rules there. He can attest to my behavior at that place. That's regarding the alcohol. The search and seizure, again, that I just think they just throwing whatever they could throw because that's not even a big deal. When I went to Welly Avenue, they took my sneakers. They were Jordans, and we can't even wear them in jail, and I had them sent to my job. I just want to be able. I'm 48 years old. I've been incarcerated for the last 17 years. I've spent 17 years in prison. If you add up the 15 I did and the times they bringing me back for these frivolous things with these cases, because as you can see, my criminal history has definitely changed because I went from drug charges, gun possession, federal cases, bank robbery, to miscellaneous charges like misdemeanors. The other ones have gotten annihilated. My infraction got annihilated at the last halfway house, which they didn't even put in the evidence that the person took my charger. And I was being discharged to the Roger Emerson house, which is the parole house, the apartment I live in, the following day. So the person that I was living with took my charger and wouldn't give it back. Got aggressive with me. None of that's put in there because it's always designed to make me look like the bad guy, Miss Saunders. I am I've been out a total of 1 year. If you add the time I've spent on my own in the last 17 years, I'm not a threat to society. I don't tote guns. I don't gangbang. In fact, my job, we go against community violence. We work with community violent prevention on Aspen Street off of Dixwell. I'm in the city doing things for the community because that I feel like I've done nothing to the disenfranchised population of my community my whole life. I've added to that property, the valuing of our society. Now I finally got a job to give back, and I'm doing that, and I love my job. I'm getting $22 an hour. I saved $3,000 at the Roger Emerson house to put a security deposit on my own apartment when that time was up. I don't feel like I'm willing to go on a bracelet if I have to for a certain amount of time. I just want, my company is ready to bond me out. I didn't understand why the DNR was given to me for such charges like this when it's not a I'm not a threat to that building. I'm not a threat to that person. I haven't been a threat to anybody. Everyone wants to try to make me, Miss Saunders, out to be this violent person because I speak up for myself, because I believe in my own intelligence, because I'm not a slave to the state and I have to behave a certain way to where I was appalled that they even gave you the exhibit about parole when they came to see me in 2019 about parole. I think it's called Decision something. Right, all that was just to misnomer me in your eyes and put some type of cloud in your eyes so that you could say, oh, don't give this guy a chance. He's a piece of shit.
You are trash, Lindsay. You are trash.
I'm saying to you, Miss Saunders, I got an apartment still waiting for me from a guy who runs the apartment that can back me and attest to my behavior at that apartment, that I'm one of the best residents there. I have a job. If I could, you can call my boss right now. They'll pay for my bond. And I can fight this case on the street, which is, I feel, because of the severity of these charges are extremely minimal. And I don't have a history of going on the run. Like I said, I was told to report on Friday, even though Thursday on the 16th, they gave me a misconduct and the situation was over. But apparently the judge, during a 5-day span from January 13th all the way to the 17th, decided probable cause. I feel as though because I'm not a threat to nobody out there, the protective order's already, I didn't challenge it because it's never been an issue about wanting to see her or be around her. The parole condition can be added to stay away from that building. I probably won't even drive down House Street anymore. That because of those precautionary measures that were set up, which if I do violate, which would make a felony, as far as it won't be misdemeanors if I violate the protective order or if I violate the condition. So since these conditions are in place as we speak, and the frivolousness of the charges, which is a misunderstanding, which I can't argue, the alcohol has never been an issue with me.
If you are an alcoholic or were an alcoholic, you are an alcoholic today.
I don't use harsh drugs. I only smoke marijuana. And I had red wine the previous night on Wednesday because I thought I was going to get remanded Thursday for what I was hearing about the incident at Sierra. I didn't get remanded. I got remanded the next day. I reported knowing that I figured that's why they called me in, because it's back-to-back days. I didn't run. I didn't hide. I was expecting them to come to the Roger house and get me. I drove there. I left my car right outside the Grand Avenue parole place. No, they didn't care about that. And I just wanted, if it's possible, to be able to go home, make bond, go back to work, doing what I was doing, and fight this case and get it probably eventually nollied or whatever.
Mr. Bryce, I just have one question for you. When you were asked for the search, where were you? Were you still at the halfway house?
No, I was in the parole building on Grand Avenue.
You were in the parole office?
With my back face against the wall and cuffed like this behind my back with an officer here and an officer here and the state trooper reading me my rights. After he read me my rights and I heard the charges, which was stalking third and all that, I had a panic attack, which I do have a medical condition because I was in Northern for 12 years, which is solitary confinement. I didn't get out of that building until my lawsuit helped me get out because they were holding me without justification, because I've never been a physically threatening prisoner. Like, I have a bunch of tickets because I argue my case, or I practice civil disobedience. If I'm going to SEG unjustly, carry me to SEG. I'm not walking. If I do something like get in a fight or say something crazy to somebody, I gladly walk the sag. But whenever they use their authority in an abusive way, my only form of protest was civil disobedience, which I even did at the Grand Avenue parole office, and the police and the ambulance had to come because I was having chest pains. But I only did that because I can't do anything else. So it's like when the charges was read to me, Mr. Saunders, I got hypertension. I take medication right now. So, I'm back on that because I can't sleep without it in jail. I'm 40 years old. I'll be 49 in July. I need this job. I've been doing this job since July. I've 6 months. I went from part-time to full-time. I had $3,000 saved with Roger Emerson House. I got a bank account in New Haven Savings Bank on Whaley Avenue. I had things in motion. I helping my mother out. I have a daughter that I'm just finally getting to know who's in D.C. I can't afford to just be sitting in jail for charges like this when I'm not a threat to society, when I'm not showing any criminal activity. This is just a misunderstanding that unfortunately, I can't even argue it with you today because a judge supersedes whatever power you have. So all I'm saying, if you do have the power to consider releasing me so that I can make bond and even wear a bracelet for a time period, I will do whatever y'all want me to do. I just want to go back to work and save money and continue doing what I was doing. That's all I want to do. I am not a threat to no one, Ms. Saunders.
Thank you, Mr. Rouse. I'm going to take a moment before I announce my findings, okay? Okay, Mr. Rouse, we are back on record. So I just want to, before I go into my findings, I just want to make it known that I did hear your argument regarding it not being serious enough, especially in regards to the do not release and you being on the $25,000 bond. I heard that when you said your job can make the bond for you. So, and I just want to make sure that I let you know I did hear everything you said today. So with that said, I'm going to go into my findings. Regarding charge 1, as I said, probable cause was already established. I'm just doing this for the record. So no testimony was taken into consideration for charge 1 because probable cause was already established by a judge of the state of Connecticut Superior Court. Charge 2, search. I make a finding of probable cause based on your testimony today, as well as states exhibits A and E. On charge 3, no consumption of alcoholic beverages. I make a finding of probable cause based on your testimony today, as well as states exhibits A, E, and K. I find that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you wait for your revocation hearing. So this does conclude the preliminary hearing.
This is bull. Them are not serious charges of violation because they couldn't go. When I was laying on the ground, they could have went in my sneakers. What do you mean? They could have went in my sneakers when I was laying on the floor. It's not about that. You know that. I wasn't kicking. And they had ample opportunity to go in my sneakers. I sat in there for damn near 45 minutes waiting, being checked by medical and all of that. That's two. And then two, alcohol, that's not even nobody gets violated on one alcohol consumption ticket. Nobody gets violated on that when you're outside. So why is that violation now? Why is that a violation now?
Your preliminary hearing.
That's bull. You're doing that for Miss Harris. All y'all work together. Y'all don't do nothing for us. Y'all don't do nothing for our people. All y'all do is want to keep us in jail because y'all some bunch of house. That's what y'all are. Frankly, that's all y'all are.
You are trash.
Y'all like seeing men, your own men suffer. Look, you probably a lesbian yourself. Ain't you? You don't like men either. All y'all like that. All y'all don't give a fuck about our lives. I'm sitting in jail for some alcohol and because they couldn't search my shoes. Are you kidding me? Are you kidding me? I got frivolous charge of a $25,000 bond, which is nothing.
No parole for
You're
Tate.
all pieces of shit.
None.
Take that, bitch.
Mr. Tate is not getting parole because of anger issues. That's what's going on here. No parole.
No parole for Tate. If you want to get a no parole for Tate hat, you can check a link in the description. But man, I couldn't help myself with no parole for Tate. And hey, we're not going to have to wait much longer. We're going to go and see his next hearing, his revocation hearing, because again, remember, this was a preliminary hearing, and normally preliminary hearings are followed up by the next hearing within a few weeks or a month. In this case, we waited from February until September. I guess they just felt there was really no rush for him. And guess what? He hasn't learned his lesson. He still hasn't taken them up on getting a free attorney paid for by the state. And you know that he did the same thing for his initial crime, for what he was locked up for robbing a bank. He represented himself in that jury trial, and it was, I covered it in the last hearing, the whole article of it. It was just quite hilarious. He like approached the jury and gave a speech and said, "Jury, how do you feel about bank robberies?" And they're like, "We don't like them." And then he had his punchline. He thought the mic dropped. He said, "Well, how do you feel about attempted bank robberies?" And they're like, "Well, we still don't like it." Anyways, they found him guilty, but he's a professional victim. I think you might categorize him as he views himself as a victim, and really nothing's changed. Nothing's changed from then until now. But enough of me babbling. Let's just jump in and watch this spectacle. Let's go.
Concerning Daniel Riles, inmate number 235-288. Today is Friday, September 5th, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office in Chester Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Daniel Alexander Riles II, 235-288.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present is your charging officer. Officer, can you please identify yourself for the record?
Parole Officer Reyes.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence. That is, the better weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. Mr. Riles and Officer Riles, can you please raise your right hands? You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for today's hearing. First, we're going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to present all relevant testimony subject to cross-examination and any relevant documents. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings, and if I find you have violated one or more of the conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
Yes, can I just state for in interest of the time and other hearings you might have to do today that there is no question about whether or not I violated my special parole, because I had police contact in the fact that I was arrested for criminal trespassing. So there is no issue. I'm just trying to help you speed this up, because there's no way around.
But this is the state bringing this against you. They have to prove the allegations. I get where you're coming from. I think you're tired of all this. I believe it. I can only imagine. But let them do it, all right? And then you'll have opportunities to speak. If by then you really want to say what you need to say, we'll move on to that part, okay? But we'll keep moving forward, all right? You do have the right to be represented by an attorney, Mr. Riles. Did you have any intentions to hire an attorney?
No, ma'am.
You're okay moving forward today without council present?
Yes, because council has never actually helped in this proceeding. It just comes down to whether the BOP wants to do whatever they want to do with me. So I didn't want to get an attorney to waste his time when the decision's all on y'all.
Okay. All right, so then we're gonna move forward. You also have to receive the charges of violation. Did you receive that notice of charges?
Yes, ma'am.
Thank you. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case, and you have the right to call and examine voluntary witnesses. You understand these rights, now you're ready to go forward.
Yes, and that calling a voluntary witness, that's what I was speaking about in the beginning.
Absolutely. So if, like I said, if we get to that point of the hearing and if we need more information, we'll do what needs to be done, okay?
All right.
All right, so at this time, that your parole officer is going to review the charges that have been brought against you and the underlying information for each charge. So Officer Riles, can you please read the charges you have brought against Mr. Riles?
Okay. Charge 1, obey all laws, obedience to the law. On January 13th, 2025, you went into 48 House Street and walked upstairs to the Sierra Center halfway house on the 4th floor. You were previously prohibited from the Sierra Center halfway house and its premises due to intimidation and threats that you made toward a Sierra Center halfway house staff member. Due to your actions, Connecticut State Police issued a warrant for your arrest for 53A-107, criminal trespass, 53A-181E, stalking third degree, and 53-181, breach of peace with a $25,000 bond. Charge 2, search. On January 17th, 2025, parole staff instructed you to sit in a chair in order to search your shoes. You refused to have a seat in the chair. You also refused to remove your shoes. This violates your special parole conditions that state, I will submit to a search of my person, possessions, vehicle, residence, business, or other area under my control at any time, announced or unannounced, with or without cause, by parole or its agent to verify my compliance with the conditions of my parole. Charge 3, no consumption of alcoholic beverages. On 1/17/2025, you rendered a urinalysis. Your specimen number P3482418 was sent to Premier Biotech Labs for ETG alcohol testing. On January 22nd, 2025, Premier Biotech Labs confirmed your specimen was positive for alcohol. This violates your additional condition that states you are prohibited from the consumption of alcoholic beverages.
Thank you. And the evidence submitted has already been identified at the preliminary hearing. There was new evidence provided, and that's going to be identified as Exhibit N, the docket number 914 as minimus. Exhibit O, the disciplinary reports, and Exhibit P, the video evidence from 1/17/2025. In addition, the state did file 2 addendums to the parole violation report. Officer Rice, can you please review the addendums that you submitted?
I'm sorry, you said read the addendums?
Yeah, can you please?
Okay. So addendum number 1, parolee Daniel Rouse appeared in New Haven Courthouse GA 23 under docket number N23N CR 25-025-8051 for the charge of 53A-107A criminal trespass, 53A-181E stalking third degree, and 53A-181 breach of peace. All charges were substituted to 53A-182 disorderly conduct. Mr. Rouse pled guilty to 53A-182 disorderly conduct and received an unconditional discharge. Addendum number 2, parolee Daniel Rouse was charged with 53A-181 breach of peace and threatening second degree. On 3/30/2025, parolee Daniel Rouse appeared in New Haven Courthouse GA 23 under docket number N23N CR 22-002-44914-S, to which he was convicted of 53A-181 breach of peace and 53A-62 threatening second degree. He was sentenced to 4 months jail, execution suspended with 2 years conditional discharge. On 1/17/2025, parolee Daniel Rouse was arrested and charged with 53A-107 criminal trespass, 53A-181 stalking, and 53A 181 breach of peace. All charges were substituted for 53A 181 disorderly conduct. This addendum is being submitted to the BOPP due to aggravating information and for the purposes of sanctioning. Parolee Daniel Riles appeared in New Haven Courthouse GA 23 under docket number N23N. Sorry, I'm losing my space here. On 7/30/2025, parolee Daniel Riles appeared in New Haven Courthouse GA 23 under docket number N23N CR 25 025 8051-S for disorderly conduct. Parolee Riles pled guilty to 53A 182 disorderly conduct and received an unconditional discharge. Based upon this charge of disorderly conduct, New Haven Court found parolee Daniel Riles guilty of 53A 32 violating conditional discharge and sentenced him to 10 months jail on 6/23/2025. Parolee Daniel Riles has been incarcerated at Cheshire CI since January 17, 2025. Since that time, he has incurred 12 disciplinary reports for interfering with safety and security, disobeying direct orders, refusing housing, contraband class A, flagrant disobedience threats. BOPP has acquired a video of the events that occurred on 1/17/2025 at the New Haven District Parole Office. Video has been updated into PCS video evidence. PCS is, yeah, I think that's it. Yeah.
And it was added, okay. So Mr. Rouse, just confirm you have received the notice of parole violation and the parole violation report and all the other documents identified for today?
Yes, ma'am.
I did not receive any evidence from you right now. I have noted the witness. Do you need any time to submit evidence upon your own behalf?
Yes, I need you to make a phone call
Is
so
this for
that
your
my
lawyer?
the purpose, the evidence. I went to the halfway house because I was sent there from my boss to go
Okay.
there. All the halfway houses in New Haven I was in charge of. So I dropped flyers off because we do re-entry work for prisoners. So I went to Walter Brooks. I went to the public libraries and Sierra, which is on 48 House Street. That building housed two halfway houses, Roger Sherman and Sierra. And some other agencies are in there as well, as far as a female sober house or something like that, a pretrial. It's a building that holds a bunch of things. So I went there. That I was never prohibited from that building, and this is why them charges got reduced to the disorderly conduct, because in order to get the warrant signed, they said that I was prohibited by the court, which there was transcripts that said there was no prohibition. They said I was prohibited by parole. Parole made that not one of my conditions to never return there. And then they said I was prohibited by the halfway house themselves, when that's impossible, because the day I got arrested for the threat to Priya, a staff member, nobody told me as I was leaving with the police in handcuffs, don't you ever come back to the building again. So I never knew in 2 years that I could not go in that building for privilege responsibility. I didn't think that they would house me there, as far as like discharge me to that halfway house. Maybe Roger Sherman, but definitely not Sierra, because they don't usually send you to a halfway house you get booked from. Yeah. However, for 2 years, I never went to that building because I had no reason to be there. But being that now I have a job and doing the same work that halfway houses do, that's the only reason I was there that day.
Okay, Mr. I have your testimony. I really do want to stop you though. I want to let the state talk, and they have to fight the case. Let them do it. But I have taken that testimony right now, and we're gonna move forward. But I heard everything you said. I'm gonna let them do it. Okay. And then you'll have another opportunity, but I do want to just let you know at that time also, you do have the right to remain silent as well. Okay, so at this time, it is going to be the state's opportunity to make any comments or speak towards the charges, and then you'll have another opportunity if you choose to do so. Okay. So Officer Ross, would you like to make any statements towards the charges?
Yes. Regarding charge 1, we can acknowledge that there was no parole condition or court order that stated that Mr. Riles shouldn't have been at the Sierra Center. However, he was told by several staff members that he wasn't to go there. We can acknowledge that for charge 1. Also, Mr. Riles says that he was a supervisor for the company he was working at, and also acknowledged in his preliminary hearing that he had 2 other people with him. Using proper judgment or his judgment, he could have sent someone else in that halfway house, knowing what his history was with staff there. As far as charge 2, the search, Mr. Riles was not cooperative with the search on January 17th during the remand. He refused to allow us to search his shoes, and that became an entire issue with him practicing what he called civil disobedience. And that video was also submitted for BOPP review. He continues to not follow instructions given by staff or from parole staff, and completely disregards his parole conditions. As regarding to charge 3, no consumption of alcoholic beverages, this is his second violation of this. There was a finding made in September 2022. There was a finding made by the board that he consumed alcohol. So although he says that he doesn't, and that he doesn't drink any alcohol, this is his actual second violation for that.
Thank you.
That's all I have regarding the charges.
Okay, thank you, Officer Rouse. Okay, so Mr. Rouse, this is now your full opportunity to make any comments towards the charges. However, please know you do have a right to remain silent if you choose to do so. So any additional
your
comments?
Your name is Mrs. Monroe, right?
No, Tricello.
You're who?
I'm Officer Tricello from the board.
All right. When parole officer Rios says that staff told me I was prohibited, can the state elaborate on what staff told me this? Being that she just admitted that parole never stated this and never made it one of any of my conditions, which it is now. It's a condition now. It wasn't then. When she says staff told me, what staff? Because I left that halfway house December 2022 in handcuffs for only threatening to snitch on a female that was sleeping with a client. That was my threat, an idle threat. Now, from that day, December 2022, December 28, 2022, I've never been back to the building. So what staff member told me I could never go back? Second, had I known that I could never go back, I would have sent a person who was with, because I was in charge of 2 individuals and my job duties, that one of those people that worked for me or with me was in my car that day. He lives in Sierra. I would have sent him up there with the flyers instead of going myself, had I known that this would be an issue with me just dropping off a flyer. I was in the building 25 seconds, and that's on video. I didn't create a disturbance. I didn't even know Ebony Broadbell was working that day, what her schedule is, because mind you, I haven't been in the building for 2 years. So I didn't even know if she was still working there. I didn't know when she was working. My duty was to drop off flyers for their bulletin board, which the camera footage of me going in there that the state police had shows the bulletin board right there when she opened the door. And then I left. The whole purpose of me going there was to ask permission to pass out flyers when they bring their clients out for smoke break. That was what I went up for, because I didn't want to walk up to clients on a smoke break outside and pass out flyers without their permission. So I said, on your next smoke break, will you allow my guys to pass out these flyers to your guys? The lady said, come back at 2 o'clock, which was a setup, because the whole time they were calling the police on me, which I didn't know till later. But no staff member ever told, if all I asked is for the state to give a name or circumstance or situation where I had a meeting with some staff member who relayed this to me that I could never go back to that building for any reasons whatsoever. Second charge, I got ambushed at the parole office. Mind you, I went to this building on January 7th, January 13th, 2025. Friday, the warrant got signed for the criminal trespass, stalking, and breach of peace. I was called in to go to see my parole officer supervisor because she wanted to talk about that incident. I go back there, and as soon as I go through the metal detector, they surprised and jumped me and throw me against the wall and cuff me and say, I see the state police in there. They say you're being arrested for criminal trespass and stalking and breach of peace. The video that they submitted, which they only submitted to you to make me look like some terrorist, evil, violent person, even though I practiced my right to civil disobedience because I didn't agree with the unlawful arrest. Because once I heard the charges, I knew I wasn't criminally trespassing because I was never trespassed in the first place. Definitely was no stalking because this is my first time in the building in 2 years. Who wastes 2 years to stalk somebody? Third, I didn't create a scene or a scenario in the building. When I was told to leave, and yes, you could pass out the flyers when we come out there for smoke break, I left. So when I heard the charges, I was distraught and indignant, miss. I'm talking about I got a vehicle out there that's parked on the side of the street next to a drug environment, a drug area and projects, who I know is going to take my car and my rims. Parole didn't care about that they're sending me to jail with my car keys, and my car is going to be left outside the parole house. So my housing situation, my job, I left work to come to this setup or ambush. So because of those situations that I'm involved with personally with my own life, I had chest pains. I got distraught. I got angry. And I can't do anything physical. I can't push nobody. I can't spit. I can't resist physically. I can't do anything because that's just going to make matters worse. So what I did, once I got cuffed, this is the video that she submitted, which was only submitted to make me look bad, but this video will corroborate that. When I was cuffed against the wall, I was read my rights by the state police officer. So now I'm therefore in his custody. So what they wanted me to do was lift my foot up so they could take my sneakers off. And that's what I refused to do because I said the state police do that when I get to wherever I'm going. You patted me down, you cuffed me, you put me against the wall. I didn't resist in none of that process, even though I was hearing trumped up charges that I did not commit. Mind you, I'm thinking about my vehicle. I can't say, since you're my parole officer, Rios, and you're the one in charge of me and my development and me integrating back into society, can you take my car keys or can you allow me to call someone to pick up my car so that my car doesn't get stolen while I'm sitting in jail? None of this they care about. So once my chest started hurting from the amount of anguish and indignation I was feeling, because as a so-called Black person, we're not allowed to get angry. So I'll use the word indignation, which is morally permissible. I said, my chest hurts. Can you call the ambulance? I'm having chest pains. And they laid me down, and I told them I'm doing civil disobedience, meaning I'm not resisting, but I'm not helping you bring me anywhere. If you want to bring me, you can put me on it, carry me, put me in a wheelchair, whatever you want to do. First, get the medical people here because I feel like I'm having a heart attack because this surprise ambush created that within me, that trauma. And it brought me back to what I experienced in prison from these people with how they handle us physically. So the third charge of I'm a Muslim. I don't drink alcohol. I've been on special parole for 4 years now. I have 1 year left come January. And in that first alcohol incident, they because I didn't have marijuana, I took a couple nips. I didn't want to go back to the halfway house sober because of what I was dealing with in that halfway house where these women constantly get walked out for sleeping with clients. Sierra, if you do the history, but after this hearing is over, you'll see that countless women have been walked out and fired and charges of sexual assault was pending on one of them, which they interviewed me about. So this place has a history of undue familiarity with staff and clients. So that day I chose to drink a couple nips so that I would feel better and go to my room. Now, I walked into a urine that day. I got evaluated for a drinking problem. My psychiatrist and the people that I went to for that said I don't have an issue with drinking. I don't drink. I'm a Muslim. I told them why I had to sit that day, and they say you don't need a program. They didn't violate me for drinking. They didn't say I was going back to jail for drinking on that first occasion. So this occasion, on Monday on the 13th, when I went, on January 13th, 2025, when I went to drop off the flyers at that place, which I didn't know I was prohibited from, Wednesday I had heard that they were trying to get a warrant signed for my arrest for criminal trespass. So I took my girlfriend out for my one last meal because I felt like any day they could run, because I'm living in a parole house, miss. It's an apartment, but it's a parole house where you like transition from a halfway house and you save money. I saved $3,000. I was about to leave and get my own housing. I had a vehicle registered and insured. I had a job consistently. I never had any issues at this parole house. And the person, Roger Hines, can testify to that. So I went out and I had wine with my steak. That's it, wine. I'm not an alcoholic.
So I'm gonna refocus you, Mr. Ross. You did ask the state a question. Do you want to go back to that and have her answer your question?
Yes, who told me that? What staff members told me I was prohibited? Please tell me that, because I want to know where, when, and who. Because this never happened. They're just saying that to justify the fact that after that situation with Ebony, maybe victim's advocate or maybe parole was supposed to make a condition or prohibition or trespass me from that building, but that never happened.
Let's let her answer. Officer Rios, can you please answer? Question.
Okay, so I will say that at the time of the arrest, I was not his supervising officer, but I have been told that he was told. Also, I will say, based on the violation of conditional discharge that he received, where he was sentenced to 10 months jail, the judge found that he violated that the stipulations that the court gave him back in 2022 based on the incident with Miss Broadbell. That's how I answer.
All right, and a real quick response to that, miss. The violation, the 10 months that I just got, see, when I got arrested for the threatening the PREA, Miss Broadbell, in December, because I did the PREA with parole Babbage. I eventually did the PREA in jail that I threatened to do weeks later, which my lawyer has in court. We presented this at my hearing for the conditional discharge. My condition, what I was sentenced to was 11 months suspended after 4 months, 2 years conditional discharge, meaning I can't get in trouble or get arrested for anything for 2 years. Now, I almost made that 2 years. I missed it by 2 months because March 28th, it would have expired, that conviction. But because I got arrested for these charges that later on were found false because there was no evidence of criminal trespass, stalking, or breach of peace, I only took the disorderly conduct so I could get this matter over with, which they gave me unconditional discharge, no jail time, no sanctions, no other probation, nothing, because they realized what this guy basically did 10 months for a false arrest because he never violated. That's why I don't have those charges anymore. They realized that no one ever prohibited me from the building. There was no conditions. There was no protective order. There was nothing. He didn't stalk because there was no other incident where I reached out on social media or I saw her somewhere else to where a second appearance in the building would constitute stalking. Remember, this is my first time there in 2 years. So I proved that in court. Then the breach of peace I proved I didn't do. So technically, the reason I just got the 10 months is because what I couldn't get around was the fact that even though I got arrested for false charges, I still got arrested, which violated the 2-year condition. So they gave me, out of 11 months, 10 months. I tried to get 6 because I had 6 in. He gave me an extra 4 because of my having 6 felonies in my past. That's what he justified, because he could have gave me time served on 6 months, because you get up to 11 months. So he could have been 5 months, 6 months. So he's at 6 months when I requested, Your Honor, I've been in since January, it's June. These charges was frivolous. I didn't do anything. It was a misunderstanding. He said he asked the prosecutor, how many felonies does he have in his record? He said 6. Not mentioning there was only 3 real ones. The other ones were failure to appear and some and miscellaneous stuff. He gave me 10 months. So at the hearing, there was nobody evidence of anybody telling me, like she says, she was told. Now, I'm not saying she wasn't. Somebody lied to her, because no one ever told me that I could not go in that building. Because had they went in there, had they did tell me, I would have sent the Cliff who worked with me and lived there. You go in the building. I don't want any issues. What's in the Ebony might still be there. And plus they told me never go in. Now, what I don't understand really quick is hindsight is 2020. Now the state parole realizes there was no restraining order condition. They don't know what staff member said what. They just saying that someone told me, but she won't even say who told her, so we can keep the link in the chain and find out if I was ever really told. She just says she just allowed to say someone told me, but I won't say who. What anybody can say
she
that.
won't say who she was just told, but she answered the question, and I've heard both of your testimonies. I'm getting both sides. Again, I get your frustration. She mentioned she was told about it. That's her testimony to it, okay?
But I'm the one that got arrested. I got arrested for this.
She has to, again, she has to make the case, right? So that's her testimony to it. We can't force her to, unless Officer Rios, do you know the exact at this time?
Right, I understand that,
Not
but
at this
I just
time.
don't understand how the state parole is allowed to make mistakes that cost me my freedom. I could die in jail. I'm not promised to go home from here. People get killed. Somebody just got killed in McDougal because the guy didn't want to sell it. People are epping out on Deuce and K2 every day, going to emergency trips to the hospital. This is crazy in here. So what I don't understand is hindsight is 2020. They see now that those charges that they booked me was no evidence of that. I just had to cop out to something so I could stop going, because you know what they say? That y'all can't have this hearing until my case in Superior Court is done. So I'm held hostage. If I want to wait and go to trial, I gotta sit in jail because they wouldn't give me release, get rid of my DNR and let me make bond and continue working and living where I was living and fight the case on the street. I gotta sit in jail and fight the case. So it doesn't benefit me with a job that's still waiting for me, thank God.
Yeah.
Which you will see when we call Tommy, if that's permittable.
Yeah.
I need to get back out there and continue with my life, because jobs do not come easy. I'm 49 years old. I done gave them almost 17 years. I was sentenced to 15 years jail, 5 special. I done did about 17 of that time in jail. So I'm like, my charges. One last thing. I know you're ready to continue.
Yeah, because
I
understand you're very frustrated, and it sounds like it's a lot. I understand.
I keep coming into jail for I'm not toting guns. I'm not selling drugs. I'm not in gang activity. I got misdemeanor charges that were a misunderstanding, and I sit in jail 10 months.
Yeah.
And I'm just not supposed to be. This is what I don't understand. I can't get angry. I can't get indignant because it gets used against me.
You can feel your emotions. We just have to also proceed with how we're going to move along here, move forward from it. So I am going to announce my findings now, and then we'll move into the part for any additional information if the findings are made. So with that, I am going to make a finding on charge 1, the condition of obedience to the law based on your conviction of that disorderly conduct on the 30th of July when you received the unconditional discharge. In addition, the evidence that supports that charge is Exhibit A, E, and G. On charge number 2, the condition of search, I'm making a no finding as the state failed to submit sufficient evidence in support of the charge. On charge number 3,
I didn't hear the second one. Your
I'm
second
making a no finding. No finding as the state failed to submit sufficient evidence in support of the charge. On charge number 3, I am making a finding of no consumption of alcohol based on the evidence presented in state's exhibits A, E, and K, as well as your testimony here today. And I'm also going to make a finding on charge 1 based on testimony today that you made earlier that you did have police contact. So with that, that does conclude the fact-finding portion of the hearing. Before I make my recommendation, the state is going to have an opportunity to speak towards your background and history. Once state is done, you will have the same opportunity, okay? So just give them a moment to say what they need to, you will have the same opportunity. The purpose of this part of the revocation is to help determine what outcome I would recommend. So Officer Ross, would you like to make any statements or comments towards Mr. Riles' background and history?
Yes. So I want to begin by speaking to Mr. Riles' behavior. I believe that he likes to, or he says that he was practicing civil disobedience. That's a term that he uses when he desires to be non-compliant with staff. I will say that even in this, he has obtained 371 tickets, with the last 13 being since he's been incarcerated since January 17th, for things such as threatening officers, flooding his cell, interfering with safety and security, disobeying direct orders, contraband. At the time, in this time when he was as he's incarcerated now, this should be the time where he could show not only himself, but parole and the board that he can be compliant. Instead, he decides to be non-compliant with staff. Also regarding the consumption of alcohol, again, this is the second violation that he's had. He says that he's a Muslim, he doesn't drink, he doesn't do those things, but yet it continues, the pattern shows that he does in fact drink. And then I will say regarding even in his preliminary hearing, when he became disrespectful toward the hearing officer, we continue to see a pattern of him using derogatory, verbally abusive, misogynistic, and antagonistic comments, as well as racist comments toward others.
You're doing that for Miss Harris. All y'all work together. Y'all don't do nothing for us. Y'all don't do nothing for our people. All y'all do is want to keep us in jail because y'all some bunch of house. That's what y'all are. Frankly, that's all y'all.
I believe that, Mr. Riles hasn't changed that behavior also, especially when there was a finding back in 2022 when he walked up to a female and told her that, she shouldn't be liking girls and that she should want dick or whatever the comments were. I believe that he was convicted for a breach of peace based on that charge.
No,
even on the date of the remand. Let me finish, Mr. Rouse. Thank you. Even on the date of his remand here at the New Haven Parole Office, he was very misogynistic toward the female staff here, including my supervisor. Called us bitches, called her a bitch, said that no one likes us. She don't have a man. She's flat-chested, and all of these other derogatory statements toward female staff. Which leads me to still say he hasn't changed his behavior. The video evidence that was submitted by PCS could attest to that. And I initially requested a 6-month sanction based on the graduated sanctions, but since he's since received 2.5 months and 7 months, I'm asking for the board to completely revoke. Because he has not changed his behavior and he continues to display the same behavior.
Yeah. 1 second, Mr. Rouse, and then that'll be our opportunity. So again, so this is your opportunity, Mr. Riles, to make any statements regarding the violations, backgrounds, any history information you'd like to provide at this time.
I'm just gonna say, I'm gonna talk about what matters. My incarceration history and whatever happens in here, it's always more to the story than what's presented in black and white. In black and white, I'm a so-called terrorist, or I'm the worst of the worst, or even though I don't have any assault charges on staff, I don't have any drug possession charges, I don't sell drugs in here, I don't show my private parts to women, I don't beat up, I don't have a bunch of fighting tickets. My disobedient behavior in prison probably will never change because there is no oversight for the Gestapo-like treatment that we receive from staff in here. And my only way of fighting back against Gestapo-like treatment is to not be, is to be disobedient or make them have to do paperwork or make them work a little harder than necessary. That's all I've been doing. That's the only fight I have. I've never been the type of person that gets abused because a person has the authority over me and I do nothing. If I can't put my hands on staff because that would be assault or that would be violent behavior, then the only thing left is my mouth, miss. If I want to cuss a staff member out because that's the only out I have, because they have the power to send me from one part of the jail to the next and put me in SEG and go through my property and break my television or do this and do that or mess up my clothes or take my tablet from me. None of this stuff ever gets talked about. And I'm not going to talk about it now. What I'm going to talk about to you, though, is that on the street, out in society, I follow the rules. My car was registered. My car was insured. I was working. I was saving money. I was staying out of trouble. I wasn't hanging out in the streets. 2 alcohol urines in 4 years is nothing. That's not evidence of alcoholic abuse. I don't use harsh narcotic drugs. I was never found. Fentanyl was never found in my system. PCP, cocaine, crack. Only marijuana is what I smoke for my trauma from being in this place. I see a psychiatrist every month or couple weeks. I forgot. I think it's every month. I sit down with a psychiatrist out there per parole. They say I got to meet with mental health. I do that. I'm doing fine with that. So what happened that day when they arrested me? I'm not proud of what I said. I'm never proud of verbally abusing females, period. I have a daughter that's 20. I have a mother and 4 sisters. But what I seem to see, and is not really spoke about because it's uncouth, is that a lot of the parole officers are female and lesbian. So, not that their sexual preference matters, it doesn't. But what matters to me is how I'm treated as a man, as how I'm respected as a man. I'm not given any respect from these women. Mind you, they're a woman before they're an officer. I'm a man before I'm an offender. I'm still who I am. So once I was treated with the utmost disrespect and tricked to show up and ambush like some criminal that might run, I was living in the parole house. If they wanted to arrest me, they could have came to my job. They could have came to the parole house in the middle of the night. They chose to set me up. Because I'm thinking, remember, the incident with me in the halfway house was Monday. I was going the week. I went to work Tuesday, Wednesday, Thursday, no issues. Didn't go back to the halfway house that I was supposedly prohibited from. Nothing. Didn't even know I was going to get arrested until word got to me Wednesday night. And that's when I went out and had my last little dinner because I knew what was going to happen. But I didn't know when. So I get a text saying my parole from Rios. No, we just spoke about this on Thursday.
Yeah, I know they ambushed. Like I do get that. I want to hear more about what your plans are. Give me something positive going on. So you're gonna work. Let's focus on because I know that you feel a certain way towards what happened. As I didn't experience it, that's your experience. But right. Tell me something positive. What you have a full-time job? You said.
Yes, I'm registering felons to vote. I'm fighting against slum lords in my community. I'm fighting against gang violence. We have a program where we work with Stop the Violence campaign. On I think it's on Dixwell Avenue with I forgot the dude's name, June Boy, and Scott X. Like I'm working. I was always a detriment to my community, and I see my community is getting worse with these young dudes, the Kia boys, and all this stuff going on. So as a 49-year-old that's been in jail half my life, I lucked up and found a job to where I can honestly contribute to my community in a better way and show them, look, yeah, I was in jail. I did time, young man. I was the worst. I got 400 DR tickets. Yo, I know what I'm like in jail because that's the only way I have to fight. But there's an alternative to that. I'm helping people get felons that come home, get their driver's license, get their ID, get job training, resume training. We're helping people sign up for New England Tech, learning how to be truck drivers. I'm registering people to vote. I was working with the mayor office last November. I was outside City Hall every night, registering people to vote, passing out t-shirts, giving them donuts and coffee for voting, giving them a sticker. I'm doing positive stuff in the community, and Parole knows that. They just want to, I just don't understand how I'm always looked at for what I do in incarceration when I shouldn't even be here, opposed to what is he doing on the street? I've always had a job since I've been on special parole. I've been driving. I haven't stolen a car. I haven't registered. I bought a car with cash. I have the title. I've transitioned to a housing where I have my own space and apartment from a halfway house, because halfway houses are not good for me. So I have a job.
I'm gonna stop you. What is your plan for housing?
That's why I wanted you to speak, because my boss,
we're
we're set up with transitional housing programs, so we have connections with that. So he can get me into that, being that I already work for Full Citizens Coalition. And his number is.
Do you have an address and phone number for him and name?
203. He's my director.
BATTLE.
Yes, ma'am. He's in charge of me. He's my supervisor.
And you said, what's the housing's address? What's the address where you'll be going?
He would have to give you. That's why I wanted you to link him in on this, because he was waiting. Right now, he's currently still waiting to be linked in so that he could be on the screen and you could ask him about these things. That's what.
His testimony though for that part isn't part of it. Like I need to know the housing from you. You have to actually give it to us. So when you leave today, call him up, get the address that's available to you, put it on an inmate request, send it to your IPO, and she'll get it to me right away.
IPO, what's that?
IPO Michelisi, the officer
that works here.
Cheshire. Correct.
Okay,
yep,
so give her.
Yep.
So give her all the info. All right. So give her all the. Does she need to talk to Tommy or you?
We won't. We have to send that stuff to the field. Your field officer will contact with him to do the housing visit, stuff like that. That has to be done. But we need that information from you, not from him. So get it all in and make requests, send it over, okay? But I'm gonna note that it's Tommy Battle and it's transitional housing, and we have his phone number. We just need an address of where you'll actually be going.
Right. And one last thing.
That's fine. Yep.
I want to tell you, to be honest with you, I'm not trying to justify cussing people out because I got handcuffs on me and I'm wrongfully being in prison. I understand that that's not supposed to be my remedy for something that's happening to me that could jeopardize my life and freedom. I'm not justifying that. I just want you to understand that day I was so indignantly distraught that all I can control was my physical behavior. Because I knew that if I don't do that, I'm going to make my situation worse. And I'm not a violent person. I don't have any shooting cases. I don't have any beating people up and right. So that day, the only thing I felt like to get the anger and frustration out was to attack the people that are not really helping me like they're supposed to.
That's something you need to work on. Just right.
That's why I go every month to see my psychiatrist who helps me with my anger issues. But I'm not a violent person, and she would attest to that. It's just that I feel like free speech is free speech. If Trump could say what he wants, why can't I say what I want?
I'm going to refocus us, Mr. Rollins. We got to get back on track, okay? So I'm going to make my recommendation unless there's anything pertinent, new information that needs to be said at this moment. Officer Rouse, are you good with me going forward?
I just want to kind of emphasize that this is Mr. Riles' fourth violation of special parole, and I'm still requesting a full revoke based on his actions and as a graduated sanction, since he has had a 2.5-month sanction, a 7-month sanction, and now a 10-month sanction, 10-month incarceration from the judge.
All right, and just this, the 4 violations.
Yeah.
Real quick, the 4 violations. The first violation, which she's not gonna say, is I refuse to sign my conditions because they had some type of right. I never left the facility.
Yeah, I've reviewed everything. I have access to what happened at those hearings.
Right.
It's okay. So I'm going
Right,
to
and
now.
the only reason I got 10 months is because I can technically not get out of violating a conditional discharge when the condition is not report every month, just don't get arrested for 2 years. Now, I happen to get arrested under false charges. I owe that 10 months. There's nothing I can do about that. I tried to fight it. Now, he said, the judge said there is no evidence that you were trespassed or that you stalked. But the fact that you got arrested, Mr. Rouse, I have to give you the 10, up to 10 to 11 months. So that's why I got that.
I understand that. 100%. I do understand that. I read it somewhere. I get that. So I have listened today. I did review everything.
Wait.
In your
you
file.
don't know, and I have to go to court Monday, right? Because they didn't count my jail credit from January to, I got arrested January 17th. I got a $25,000 bond. They served me the violation of the conditional discharge on March 28th. So when he sentenced me to the 10 months, my lawyer forgot to have him count the 70 days from January 17th to March 28th, which would apply to the 10 months. So they started the 10 months from March 28th, which they're going to fix on Monday, so that my discharge date is November 16th. From the 10, that's when the 10 months will expire, when they count the 70 days on Monday. Because they do that now. They're making records department they're making the courts have to say count such and such day now.
Yeah, the court has to give the jail credit.
Right, and it's crazy, but
I am going to make my recommendation now, though, okay? So I am going to recommend that your probate revoke Mr. Rice. I'm also going to recommend that you serve an approximate 10-month period of confinement as a sanction. That's with the reparole date of November 17th, 2025. With that, I'm going to recommend the following conditions: no consumption of alcoholic beverages, behavioral management program for anger management, no contact with co-defendants Robert Lee, no contact with victim R.B. and Chase Bank, Main Street, Bridgeport, a general no contact with E.B., a general stay away from the Sierra Center halfway house, no contact with minors, mental health treatment, and I'm doing a MOA stipulation. What that MOA means is that if for any reason you don't get that jail credit Monday and your end of sentence is still January, we are allowing DOC to review you for any early releases that are available to you at that time. That's what a MOA stipulation means. I'm recommending November 17th, 2025. That recommendation is going to go to the board in 2 weeks. So on September 18th, Mr. Rouse, board can do a few things on that day. They can adopt my recommendation if they choose to do so. They can lower it if they choose to do so. If for any reason they would want to see an increase in what I'm recommending to you today, you'll be brought back for a third hearing to address their questions and or concerns.
Wait, can you repeat that? You said, just so we clear, you're giving me the 10 months and it's running with the 10 months I just got. Once I get that fixed, my EOS date would be November either 16th or 17th for both 10 months. However, on that day, being that I do my part and I get them the information for my housing and stuff and my job and stuff like that, once that situation is done with the people here at Cheshire, on that day, I'll be released to whatever transitional housing.
The board is going to vote on it on September 18th. As long as they agree to that, then yes, you'll be notified a week after that hearing on September 18th, whether or not they agree to it. If they do, yes. But that's if you get your jail credits. Just know that that's the thing. That's why I did the MOA stipulation. It's called MOA. That if for any reason that jail credit, whatever happens in court Monday to you, we don't know at this point, but that way, DOC, if there's any ways for you to be released early on that new sentence, we just say, hey, it's up to you, do what you want to do. So there's a chance you can do that EOS till January. If that jail credit isn't changed. You don't know what's going to happen Monday. I just want to give you the information so you're aware. For your special parole purposes, it's November 17th, 2025. As
Right,
of
and I
today,
need
that's the
to-
recommendation.
Right, and I need to have the housing situation done before September 18th as well, right? So that
No.
the people that's voting could know where I'm gonna transition when I release to.
It's helpful if you can go back and make a phone call and get it on
Right,
any
I'm gonna do
request
that.
today. 100%
Right, I'm
helpful.
gonna get that done.
100%, and we'll just have it in the file so we know that you don't need a halfway house placement. It'll be forwarded to the field officers at that time. But just look
And I
out
want
in
you
the-
to know, that I appreciate you for not judging me off just the black and white, and realize that, I might not have a good rapport in the DOC, but it ain't a bad one compared to what I've seen. But on the street, I'm a law-abiding citizen. I'm following the rules. I'm working. I'm saving money, and I'm trying to take care of my daughter, who I've been away from. I appreciate what you did, man.
But you need to
Thank
keep working on yourself, Mr. Rouse, because obviously you have some
every day.
behavior situations and concerns, okay? So this
Yes,
does
every
conclude
day.
the hearing for Daniel Rouse, inmate number 235288, and you are all set today. Thank you, Officer Rouse. All right, good luck to you,
Thank
Mr.
you.
Thanks.
Riles.
How did
All
I
right,
do,
Officer
Magoo?
Rios, I'm sorry. Have a good day, everyone.
This is just totally nuts, guys. I gotta let you in on. I mean, this is nuts. Do we realize what happened? This is my understanding of the situation, right? He has this long rap sheet. He has all these felonies. He has that bank robbery we laughed about, where he represented himself as an attorney. I mean, represented himself, right? He in the jury trial, and he asked the jury how they felt about bank robbers. He thought that would get him off. Of course, he was convicted, but then the charge that he's in now. Let me pull up on the spreadsheet. Right, he was sentenced on 3/30/2023 to 4 years prison with special parole. His special parole end date ends 12/26/2026. Now he gets out like 2 years into the sentence. This is a repeat felon, right? He gets out and he immediately gets revoked. Now, what happens, we saw that revocation hearing that happened in February of 2025, not so long ago. Today it's September 2025. And he had that whole crash out. He's cursing, he's threatening, he's the whole, one of the classic Connecticut drinking the water revocation hearings. You would think you'd get punished for it. Now, the reason that he had the delay up until now in September was not because he was punished for acting out. It's because the judge sentenced him to 10 months. He received a new sentence, a 10-month sentence. I think most would think, if you're on special parole and you catch a new, I don't know what they categorized. Was it a felony? I'm not even sure. But if you get sentenced to 10 more months, that might be a reason for now when you become eligible, because they couldn't have his hearing until he went through the courts, right? Whether they found him not guilty or they sentenced him, and as soon as his 10 months are up, he was able to have this part 2 of his revocation hearing where they make the decision. And his parole officer is speaking to the interviewer and saying, hey, you got to revoke him. You got to. This is why. Look at what he did in the last hearing. Look at how many tickets, write-ups he's received while locked up. This guy is not able to be out in the public. He's not even. I mean, how funny was it when he's saying, "I'm Muslim. In our religion, we don't drink. I'll drink. Well, I had some wine with my steak." And it's like, what? And I love how his parole officer called him out on it. And and what do? They reward him. Now, it is going to the board where they're going to review it and they're going to make a decision. But we've only seen like 2 cases where it's overturned by the board. And I'm not going to wait 2 weeks to do that. But if they do make a change, I'll let you know and I'll pin it to the comment. But assume that they just agree to this. So he gets a 10-month sentence. He gets to run that sentence concurrent with his current special parole. So he's earning time. It's like the sentence means nothing. He's eating. It means nothing. It's a joke. It's a gimmick. The Connecticut is gaslighting its constituency, and it really is. I mean, like, there is a benefit if you can get on special parole. We see this all the time. And if you're backing time, it's almost like having a get out of jail free card, because you can like commit a crime and they will treat you lighter. And it's like, worst case scenario, you just run us on your current sentence. It's like you get a 2-4. You get what I'm saying? That's what happened here. He got sentenced to 10 months, but instead of but then he got revoked, which counted towards the 10-month sentence. So he got a 2-4. And then he gets let out. And it would have been so easy to listen to the parole officer who was underpaid, overworked, underappreciated, who was saying, this is my professional opinion, here's why, to just revoke him and let him get out in his full term date, which is 2026, 12/26/2026. That would have been a proper sanction and probably the best thing for him, because how is he going to succeed on special parole? I bet we're going to see him again, and we're going to see it. How is it not possible? You know, the one thing he was being honest about was that job he said he had. There is an organization that I did see a picture of him. Or I don't know if he's paid to work there or what it is, but he was on their website. You know, can you imagine someone actually putting him in a position to mentor youth or to help people coming out of prison? That's nuts. That's nuts. There is no benefit for anybody to be associated with this man. He's a man baby. He's a danger to himself, and I imagine a danger to anybody who would associate with him. There's so many things wrong with this picture that you just gotta laugh. I don't know what else to say. Guys, you hear an echo. I just moved my room and it's driving me nuts. I hear an echo. I don't know how to stop this. You know, I went through his crime in the last hearings. I won't do it again, but it was so funny when he represented himself for the bank robbery, and he asked the jury, he thought he was so smart. He says to the jury, let's see if I can pull it up. Is it right here? Maybe I'll pull it up for you because it's so funny. He starts by asking the prospective jurors what they thought of bank robberies. The jury said, we don't support them. And they said, well, how about attempted bank robberies? He thought that that would get them to work. And again, he testified on his own behalf, and he acted as his own attorney. And all these years later, he still turns down Connecticut attorney, the public defenders for the parole revocation hearings, and they are good attorneys. They actually do a really good job, and just by him turning that down, in my opinion, should have been enough to show that he has learned nothing. But this parole board interviewer just refuses to see reality. It's madness. And these poor parole officers, again, like I say, underpaid, underappreciated, overworked. You know, no one stands up and says at the baseball game, now everyone give a salute to our parole officers. No, you know, you get the firefighters, the policemen, the ambulance drivers, but not parole officers. No one thinks about them, but they're running around with a bulletproof vest, a gun, and they're chasing, these parolees around, and then they got to go and act like an attorney, and they got to do this and that, and now she's gonna have to deal with them again. I hope he gets transferred. Can you imagine? But there you have it. You can't make it up. And if he does return, we will play it in the return of section. You want to see more hearings like this? Check it out, the return of playlist. And with that, I'll let you go.
But I'm not a violent person, and she would attest to that. It's just that I feel like free speech is free speech. If Trump could say what he want, why can't I say what I want?